Angelica Cogliano, welcome to State House. Thank you for being here today.
Thank you for having me.
Absolutely. You are been a criminal defense attorney for 7 years. You are currently the recipient of, I want to read it right, of the 2024 Rising Star. You have the recipient of the 2024 Rising Star Award from the Texas Criminal Defense Lawyers Association.
That is true.
Is that right? That's
Yes, it is.
very impressive.
I was very honored.
Yeah, particularly there's so many really great attorneys in criminal defense attorneys in Texas. And, a friend of ours recommended you,
Yeah,
which was
Sam's
really,
great.
he's a good friend. Yeah, he's Sam Bassett. What a great guy. And the reason why I asked you to come on is a few weeks ago, the Texas House Criminal Jurisprudence Committee held a hearing and subpoenaed Robert Robertson to come testify before their committee the day before he was going to be executed.
Yes.
And it was unprecedented. I've been in politics 30 years, and I've never seen anything like that. It was very confusing because being in the business, so to speak, you know what the authorities are for each of the committees and the executive branch and the judicial branch and a legislative branch, and that's not one of them. But they did it anyway, and it got a lot of play. You had testimony from Dr. Phil, and
He spoke for a long time. He was well educated on the case.
he was. John Grisham. You had a bunch of folks, and we were all waiting because there was a subpoena for Robert Robertson, who's on death row,
Yes.
to actually testify. That never happened. And so, kind of long story short, we had Chairman Drew Darby come on a couple of weeks ago to talk about the committee and whether or not he thought they had the authority, and he felt like they did have the authority to. And we use the word intervene. That might not be the correct word, but to intervene in this case because they felt like they had the oversight authority to do that. And even though they don't technically have that authority, it caused enough press and enough interest, and the Innocence Project did a lot of work that a district court did give Robertson a stay. As far as I know, they have not set a new date for his execution.
A new death warrant has not been issued.
New death warrant has not been issued. And then secondly, we also had former Supreme Court Justice Craig Enoch come on because we wanted to find out, okay, tell us what you think as a former Supreme Court Justice about this authority, this separation of powers issue. And as we were sitting there, the Texas Supreme Court came down with their decision. I think you were at a conference, forensics conference in San Antonio.
I was, yes.
And I was actually talking with Judge Enoch at the time, and it said, in essence, they don't have the authority to delay a death penalty execution date, right? An execution period. And so it didn't speak to their ability to subpoena. They can subpoena whoever they want. So and the reason we're talking about all this, and we're going to get into why you're here as a criminal defense attorney, is it's raising all of these really crazy issues surrounding this death penalty case. And out of all the stuff over the last several weeks, we've never even talked about the actual reason why it drew interest from the legislature. What caused a bipartisan committee to want to intervene in a death penalty case, particularly Republicans? It's just not something I've seen. So that's what I wanted to ask you and talk to you a little bit about. And I might let you go ahead and if you want to, just kind of give just a brief synopsis on the Robertson, what happened with him, and particularly the shaken baby syndrome issue, and how it sort of caused a lot of this fervor right before his execution date.
Sure. And I wish Robertson was unique, and I think that's why it's so exciting that there's attention to this issue, even though I would never wish upon any individual that they needed to be the face of that and have their life be the face of that for the community and the criminal justice awareness initiative in general. But I hope that we can get some widespread awareness about some of the fallacies of the science behind child abuse prosecutions in general, and specifically shaken baby syndrome prosecutions, because we skipped some steps. We skipped some steps before that we should have taken before people were convicted based on this premise. Mr. Robertson was convicted based on the shaken baby syndrome theory, which was that there's 3 medical phenomenon that were considered the triad or the constellation of injuries, and that if that triad was present in a baby, then it was determined by the medical community to be diagnostic of abuse caused by the shaking of a baby. And those 3 things were retinal hemorrhaging, subdural hemorrhaging, and basically a loss of oxygen to the brain, which is called encephalopathy.
Yeah.
And those 3 things, it was thought by the medical community and the legal community, could not be caused in tandem with each other absent an abusive shaking to a child. And that turned out to just not be true. It turns out those things can be caused by a variety of different illnesses or different physical causes, such as shortfalls. There's now videos of children who have experienced shortfalls and then later go on to have the same diagnoses.
Okay.
And there's also been biomechanical studies that have been done. And there's also been medical advances. And we know that a lot of these symptoms that are considered the triad can be caused by issues in childbirth, or like in Mr. Robertson's case, can be caused by something like pneumonia. And that this diagnosis of pneumonia was present in his child, and yet it was overlooked as the causing factor for this triad of symptoms or this constellation of injuries that they use as diagnostic of an abusive phenomenon in children.
Was that brought up during the trial at all? That those other symptoms could be causing that diagnostic, check marks that were going through on the shaken baby? Was that brought up by defense on his
I
son?
know that it was known that his child had gone to the emergency room, and he had brought in his child to see a doctor several times, many times actually, in the year leading up to the child's death. As far as whether their defense team argued sufficiently these other causes could have been the causing factor for this triad or constellation of injuries, it was pretty accepted at the time in the medical community and in the expert witness community, as far as child abuse experts went, that this triad could be diagnostic.
Well, that's a good point. So just so the listeners and viewers understand, this was back in 2003? 6. I think it was 6, maybe 2006, when he was originally convicted. So it's been quite a few years.
Yes.
And lots happened since then. And a lot's happened about the definition of shaken baby, even with the American Academy of Pediatrics has even changed
Their position
their
paper
position.
on it.
Yeah.
Yes, and that's the original doctors that came up with the theory of shaken baby syndrome. It was somebody named Dr. Guthkelch and Dr. Caffey in the 1970s. They came up with this theory of shaken baby syndrome because they were seeing these injuries in children that had passed away, and they thought that it was possible. It was a theory of theirs. It was possible that these 3 symptoms or these 3 diagnostic attributes could be caused by a vicious shaking of the child. And they basically went on a countrywide tour initiative to educate parents that shaking your child could cause these injuries and cause their death. It was a PSA, essentially, that they really wanted to make sure that parents aren't doing this unintentionally.
Yeah.
And it kind of took on a life of its own after that. People accepted that as a dispositive truth, as a diagnostic ability, when really there's 2 different kinds of diagnoses. You could have a differential diagnosis, which is what is the illness that I have that's causing my symptoms. And there's something called a differential etiology, which is what is the cause of that illness or what is the cause of that injury. And they kind of mushed them together. And because we can't go around dropping babies so that we can do tests to see if these things do or don't cause, right? then we kind of skipped ahead and determined that these were, through differential diagnosis and differential etiology, able to determine the causation of those injuries before we really had that scientific backup. And so actually Dr. Guthkelch has passed away, but he has given his own input in that he thought that it kind of took on what he called dogmatic thinking. And that people went too far with it too quickly, and that he was actually shocked that it was being used as the exclusive way to convict people of killing their children when that wasn't what he intended at all. He had intended it as a theory, and it's true. Shaking a child can cause certain injuries in a child, but we jumped to the conclusion that it's the only way that these injuries can be caused in children and used it in our criminal courts a little too preemptively.
So that's really the key. The key is that prosecutors were taking what was really, as you said, sort of a PSA to parents. Hey, don't get mad and shake your baby because it can cause these injuries, and you could actually kill your baby if you do it, if you shake them too hard. And then when they started seeing babies coming in with some of those injuries, it was like automatically it must be, quote, shaken baby syndrome.
We as humans want to have reasons why children die, right? Babies are the most important part of our community and the most innocent and helpless part of our community.
Yeah.
And we certainly don't want to let people get away with it if they are abusing their children or causing their death. And I think it makes it easy for us to skip those steps sometimes because it feels unsettling to say that we don't know yet when we think we have an explanation.
Yeah.
But if you look at the history of it, Dr. Guthkelch and Dr. Caffey first called it whiplash shaken infant syndrome, and then they called it battered babe syndrome, and then they actually came out and said we shouldn't be calling it things that imply guilt before there's guilt. We shouldn't be calling people abusive until a court of law has determined them to be abusive. And so they made it shaken baby syndrome, and now we've gone back to abusive head trauma, which is what we call it now, which kind of implies that guilt before the system has been able to work out that guilt, because it's for a good reason, right? Pediatric doctors believe this to be valid medicine for all those years because they want to help children and protect children and make sure children are safe. Yeah. And we have to find that balance to make sure that we're not admitting science that's not validated in order to incarcerate people, but also making sure that we're protecting the most innocent and most helpless parts of our community, which is our children and our babies.
Yeah, no, absolutely. And then in 2013, the legislature. So we're kind of fast forwarding through Roberson's case. He's been on death row for many years. In 2013, the legislature passes a bill that essentially gives any. I think I got this right because I think Judge Enoch was mentioning this in his podcast, that any criminal felon, if they felt like they'd been convicted based on what they were calling junk science. I don't know that they used the word junk science in the bill, so I apologize if they did. But if there was if they were convicted on some science that is now sort of debunked, there you go, debunked, then they could appeal their decision. And so Roberson's team appeals his, and I believe another maybe 50 or so people maybe appealed that had been convicted on Shaken Baby. And I don't think, I don't know if you know if any of them actually were granted
not that I know
a new trial, but he certainly was not.
Well, there has been one now.
There is one now. Okay.
Yes. And actually, almost simultaneously, his name is Rourke, I think. I have the findings.
Like recently?
Here.
Like within...
Oh, yes. Oh, yes. So it was in October of this year. Oh, no, this is the reconsideration for Robertson. I apologize. But here's Mr. Rourke. And his findings of fact were filed in the trial court this year. And the CCA has already affirmed. It was April of 2019. But this year, during the pendency of the Robertson controversy, the CCA approved Rourke's reversal of his case based on a conviction in Shaken Baby syndrome as well.
Oh, wow.
And in that case, the issue wasn't pneumonia specifically. The issue in that case was whether you can have rebleeds from a short fall, meaning if a child had a fall or had something that caused a subdural hematoma or retinal hemorrhage in a child, and then later had the symptom of dying or going, unconscious based on that bleed, could that bleed have reopened and caused those symptoms again later without an intervening factor, such as being shaken by a parent or a caregiver?
Yeah.
But it came down to the same diagnosis, and the relief was based on the change in science about shaken baby syndrome. In that case, the state agreed that there had been a change in the understanding of the underlying science of shaken baby syndrome or abusive head trauma. And it was actually the same child abuse expert that testified in Robertson's case that testified
Really? I did not know that.
in the Rourke case.
Interesting.
So Rourke has now gotten relief from the Court of Criminal Appeals, but Robertson is set to theoretically be executed, I guess, if this death warrant is reissued.
Yeah.
Even though they had the same expert in their case and was reviewed by the same Court of Criminal Appeals.
And I guess each case is so different. I mean, I don't know. There's so much evidence, other evidence that all cases are different.
Yes.
So there must be at least I think I've seen from General Paxton's brief that there was additional evidence beyond the whole shaken baby syndrome he was presenting in his brief that seemed to surmount the whole issue of shaken baby. At least that was what he put out to.
Sure. And one disclaimer I'll always make is when I hear people talk about my cases in the media who aren't a defense attorney on the case or haven't been at the trial, it sometimes can be frustrating. And I certainly don't want to jump to conclusions or state things as not an attorney on either of these two cases, right? But what I will say is I think a huge factor may not be the intervening factors, and it may be that the state agreed to relief in Rourke. The Attorney General's office was not a party to the case in the Rourke case. It was still the district attorney who handled that case, whereas the Attorney General's office is involved in the Robertson case, and they are fighting very hard to sustain the conviction that is in place.
So let me ask you this question. So I'm just parsing from what you just said. The Attorney General is involved in the Robertson case because the legislature got involved, or was he involved from the beginning?
So the Attorney General's office can get involved in a number of circumstances, but it generally requires the local prosecution invite them in. I have to tell you, I'm not sure. I didn't look that up
that's
exactly
an
how the
interesting
Attorney
question.
General's office became
yeah.
the prosecuting entity in the Robertson case.
Yeah.
But I imagine that they would agree if they believed that he was entitled to relief in any situation. And so there is a big difference that whoever's representing the state agreed to relief in the Rourke case, and whoever's representing the state did not agree to relief in the Robertson case, which creates a different environment in the CCA once those findings go up, right?
Yeah.
I take some issue with the Attorney General's letter and what he claims to be intervening evidence. I know that he's relying a lot on what he calls blunt force trauma. But if you look at the expert's testimony about blunt force trauma that he's relying on in the trial transcript, what they say is blunt force trauma occurred when the brain hit against the skull. And that's part of the shaken baby diagnosis.
Okay.
Not talking about separate blunt force trauma that's causing a separate injury to the child. It's kind of twisting the testimony, which used the word blunt force trauma in the context of shaking, and using that as possible evidence of other ways that this child was abused, which is not entirely supported by the record, and it's certainly not what was argued to the jury by the lawyers that were representing the state when they were trying to convict him.
Yeah, that's kind of been the underlying issue, is really what was presented to the jury, and there might have been other evidence that should have been brought up. I mean, it seems like, and I don't know anything about Robertson. I mean, all I see is that it was a horrible, 2-year-old little baby girl that was was abused at some point, by somebody in the family, and she ends up dead, and it's just horrible. She had a horrible, 2 years of her little life. And so I really don't, I don't really know, that's why it was so interesting to me when it really raised questions with a state legislative committee, which does not take on these kinds of issues ever. I've never seen it. And I've seen them do some crazy stuff, but this was kind of out there and kind of unprecedented. Not kind of, it was very unprecedented. And I don't think it's over. I think we're going to see more of this as at least I've been told that people feel like it's going to continue, that they're going to continue. I mean, he has 90 days. So, I mean, session starts up
Yes.
in January, so it's bound to, people are going to bring this issue back up again, and probably, and the subpoena is still out there. I believe the subpoena is still valid. So,
I had heard something about the committee wanting to go to the facility that he's incarcerated
well, I
in
think
and
that's the
meeting
only way
with
you're going to be
him.
able to do
Yeah.
it. You can't. I don't see the state spending any money on bringing him in. Someone who's a death row inmate. I mean, that is so out of
Right.
out of the ordinary for a legislative body. I don't see that happening. But I think you're right. I think the only thing they could do is maybe go there.
Which is really inspiring to me. I think that the fact that there is this bipartisan support for a review of his case, what I've noticed is that everybody is very concerned about executing an innocent man, and giving him the relief that's being asked for is not declaring him innocent. It's simply giving time for the trial court to review the new science and determine if this is a case that should be prosecuted or should result in the result that it had. But if there's ever a time where I think it's appropriate for a legislative entity to take some unprecedented steps, it's when there's a life at stake. And there's a life here that many, many, many people believe is innocent, and our state's planning on executing him. And so I think for us to have bipartisan support across branches and trying to make sure we're doing this right before we do it is really impressive and important, even if the strategy that they tried with the subpoena didn't play out the way that many of us had hoped.
Well, and that's what Chairman Darby had said, is that he felt like, he's not protecting anybody that's a child abuser, but that he just didn't want to be responsible for executing someone who might possibly be innocent. And I understand that, and I think what they did is they did exactly what they set out to do, which is they slowed things down. He got to stay. It'll be another, whenever they set it, the next death warrant, it'll be another 90 days. And this will probably come back again. Now, does Robertson have the ability? I mean, once has he exhausted all of his appeals?
Yeah, so now it really comes down to the CCA deciding they're going to give him relief, or the governor deciding they're going to give him relief.
Okay. I think it's very unlikely the governor's going to give him relief. But the CCA could come back and still do something?
Yeah, so they're allowed to do what's called a reconsideration on their own motion. And so I know that Robertson's attorneys had filed a motion suggesting they reconsider on their own motion.
Yeah.
But they can reconsider upon their own motion at any time. And so if they wanted to come back, I don't know if the new CCA is going to want to take a look at it and at least make sure that the new justices with their eyes agree with the decision that was previously made. I guess that would be my hope. And my request of them is that before they just sign on to the decision that was previously made, that they look at it again and decide if you're the new CCA that's been elected by our state. Let's see if you think the same result should occur.
Well, if someone just got relief in October, it seems like there's a possibility that could possibly happen. They have reversed themselves on at least one case, right?
Oh, Rourke? Yes.
Rourke, yeah.
Rourke got relief this year. Yep.
Got relief this year, so... and all of this was happening about the same time.
Yes. Yes.
I mean, it's crazy, but it was all happening about the same time. So it's very interesting. I don't know if there's any fix to the issue of, the 2013 statute, I think, was fairly broad, it seems to me. Like it gave people opportunities. So I don't know that there's a fix legislatively for anything like this. I don't know if it goes back to the CCA and how they deliberate. I don't know.
I know that there was a prior CCA judge who testified at the same hearing as Dr. Phil. And she gave a bunch of solutions that she thought could help prevent things like this from happening. And some of them were very extreme and unlikely to ever occur, right? And some of them were more of a comment on the current state of our appellate courts. And right now, our appellate courts put more of an emphasis on finality than on truth. That happens a lot in lots of different contexts in the criminal justice system because we're very concerned about reopening cases because we don't want to use resources on things that have already been settled. And sometimes we're more concerned about that than making sure that we got it right at the trial level. And so I think that I wouldn't say that I'm an expert in legislation and offer what I think the legislation should be, because I just don't have an experience in that.
It's very, and it's also tough because the legislature trying to tell the executive branch, the judicial branch, how to do their work is that's also very complex too. It's
the balance between
you got the separation exactly. I have to ask this question just because I always think about it too. Is there any chance that that someone like Robertson, let's just use him since he's right now the case that we're talking about. Is there any chance that all of this work that's being done, with the legislature and, they keep delaying, that someone who is guilty could maybe get the benefit from the push that's happening, and maybe because we don't know, right? That's always the problem, right? We really don't know if he's guilty or if he's innocent. He was convicted, but then you've got this issue of the junk science.
Mm-hmm.
But now you've got this delay. Do you calculate that too when you're thinking about these issues? Like, could somebody get off that shouldn't?
Of course. Nobody wants all of the criminals to run free, right?
Yeah.
Like, the goal of the system is to get it right.
Yeah.
And so the fear that we have that guilty individuals can take advantage of our laws and get away with crimes is one that is scary. It's really scary to all of us that are just living in society and don't want to be at fear for our lives. And we certainly don't want to be at fear for children, anybody's children, whether we know them or not. But I think that it's important that we recognize that there's lots of ways to get justice. And if we're going to be incarcerating people or executing people, then that's the most important time for us to get it right.
Yeah.
And if we're using science to convict people, then that is something that we need to make sure is valid and true and correct if we're going to be taking the lives of individuals in our state. And our justice system is founded on the premise that we acknowledge that we have a burden of beyond a reasonable doubt, the highest burden, because it's better if some guilty people go free as long as no innocent people are convicted. I don't think that's as big as a concern in our criminal justice system as I think the fear makes us believe it to be. It is not often the case that somebody is guilty and they just get to get off, right? We're not all famous football players that are able to, litigate
right.
to the best of our abilities at every stage of a proceeding. That's just not how it works.
Yeah.
And I think we need to remember that this comes down to when can the government take the life of a citizen in our country, in our state? And do we want to allow our government to take the life of a citizen in our state based on science that isn't valid or isn't true? I think one thing the legislature could focus on, if it was less about habeas relief and more about getting it right up front, is how do we address
I
experts?
was just going to say that. I think that is exactly the problem. Is we shouldn't get to this point where we're having all of this confusion going on and people having legislative hearings and, trying to fix the problem at the back end, because it's almost too late. It really is too late, to be honest. I don't know how they're going to, it's already done. For all intents and purposes. And it really should be at the front end. I think you're right. I would be, if I was accused of something and they were using some science, I would be so frustrated if I knew, and I have a science background in addition to my legal background, but I'm really more of a scientist than I am, a lawyer, and I would be so frustrated if I felt like it was junk science,
Yes.
and someone was, trying to convict me on it because I would know, and that is a scary thought. I would never want to be in a criminal court where, you're being accused of something that you didn't do. That's also, how horrifying would that be?
Especially hurting your own kid, right?
Oh, there can't be anything worse. There can't be anything worse. So I don't know. I think what we'll see is we'll probably see a lot more of the. Looks like some of your friends are taking pictures of the van. Is that your staff?
That's my law partner. Yep.
Oh. I saw them. I was like, that's so awesome.
Yep.
So if anybody doesn't know, we're in the famous mobile studio for State House, which there's only one. So we've become a little famous for that. I actually got the idea from watching some other podcasts.
Oh, really?
Which I almost feel embarrassed to say it, but it's true. But you know who Steve O is.
Yes.
Right? Well, Steve O is the one that came up with this idea.
It's beautiful in
But
here.
he didn't have like a really, he just had a van. And I was watching him and I decided, that's a great idea because everybody I need to talk to, they're busy.
Yep.
They're busy. Like, you're a criminal defense attorney. I mean, how many times have we tried to do this? Like 3 times?
Several, yes.
And so it's easier for me to just go to you and then I can get the information, and my viewers and listeners, they want to hear this. I mean, this is important information to hear. All sides, and we're going to continue. We're going to keep following it. We're going to try to follow as long as we can keep getting people to give us more information. And we certainly, if there's new information that comes out that you think would be good for our audience to hear, let me know, and we'll do another, podcast.
Well,
we want to keep.
So important.
We
want to
keep. Yeah, absolutely. I know this is a big passion for you.
Yes.
And so we want all that information out there and let people make their decisions. They've now heard, almost all this, kind of all the sides on this issue and all the kind of little pieces, and then they can decide what they think about that, and they can let me know, and they can let you know, and hopefully we'll have an opportunity to do this again. So
that'd be great.
I really, really appreciate you coming on. This has been very educational. I did not know a lot of the stuff you were telling me, and it's particularly that someone did get relief.
Yes.
In October.
Yes.
So
Andrew Rourke did.
That's amazing. So thanks again, and we really appreciate you being on State House.
No problem. Anytime.
Thank
Thank you
you
for having me.
You bet.